Hi, everyone, and welcome to today's webinar. My name is Anna, and I'm with the New Mexico Small Business Development Center. Today, we have Larry Donahue joining us, who is a seasoned high-tech business executive and 30-year attorney. Larry will be presenting how to file business trademarks. We'll be using the Q&A function to take questions and welcome attendee participation, so don't hesitate to ask us any questions you may have. We'll answer questions during and at the end of the webinar. Thanks so much for joining us. And without further ado, I'll hand it over to you, Larry.
Thank you so much. I appreciate it. And hello, everyone. Thank you for joining us. We are going to be talking about trademarks and specifically how to file, how to register. And I'll go into a little bit more detail on the agenda and then dive right in. But before I do, I want to just a couple of quick housekeeping things. The first one is the New Mexico SBDC has a lot of great resources to help small businesses, and specifically, they're really trying to be there and help for COVID-related issues. And we have a number of links here that, as a business, you're probably going to be interested in. The other thing I want to bring up is you don't have to frantically take notes and write down these URLs. The New Mexico SBDC will make the presentation available to you with all the links. So if you want that, just you can send an email out to them and request it, and they'd be happy to give it to you. So who am I? I'm a lawyer. I am been a lawyer for about 30 years. And let me tell you, if you please mute your audio if you haven't. Also, you want to set the Zoom ratio to fit window, and it'll help with the resolution, hopefully, and make the words that I have in the presentation easier to read. Also, to ask questions, please just do so throughout the presentation. It's really hard when I do something like this. I don't know if I'm talking to a bunch of savvy, sophisticated paralegals that know a lot about trademarks already, or whether I'm talking to lay folks that just barely know some of the new issues of trademarks. And so it helps me to understand who the audience is. So please feel free to interrupt, ask questions, and I'll do my best to answer those questions right on the fly. So we're going to talk about trademarks. And I think before I can just simply tell you how to file a business trademark, it's important for you to understand what a trademark is and what the issues are. Otherwise, you're going to be spending a lot of money and wasting that money. There's a statistic out there, and it was a law review article that went into the details of trademark success. What of the trademark applications submitted to the US Patent and Trademark Office, what percentage of them are approved versus not approved? And if you don't have a lawyer helping you, the rejection rate is outrageous. It's over 80%, an over 80% failure rate if you don't have a trademark lawyer helping you. And it's my belief, the reason it's so high is most people just don't understand what the trademark rules are and what the issues are. And so when you hire like a non-lawyer company off the internet to do a quote unquote inexpensive trademark for you, they're not really going to help you with these rules and issues that you really need to know in order to succeed in getting your trademark filed. And when the USPTO charges $250 per application per class code, it can be a very expensive venture that you could be throwing your money away if you don't do it correctly. So we're going to talk about trademarks first, and then we're going to talk about how to file. So the objectives with this then is to understand what a trademark is and isn't. And part of that is really to understand what likelihood of confusion is. It's a legal test that is used by the Trademark Office to determine whether you're going to have a quote unquote problem or quote unquote likelihood of confusion with an existing trademark. And it's important you understand this. And then finally, we'll go into how you can file your trademark. Finally, before I jump into the fun stuff, I want to remind you that while I'm a lawyer, I'm not your lawyer, and the New Mexico SBDC is not a law firm. So technically, we cannot give you legal advice. So you really need to take all of this, not necessarily with a grain of salt, but view it as generic general advice, not legal advice, and not specifically tailored for your specific issues. With all of that, let's start with what is a trademark? A trademark, the technical term is source identifier. When you think or see the mark what flashes in your head as it relates to the product or service. And a trademark can be a word, a logo, it could be color, or even a sound. And so when I flash these logos up in front of you, you're not just thinking about what it is, but when I flashed McDonald's, did the taste of one of their burgers come to mind, or a thirst quenching, Coca-Cola product? When I put up Apple, did the computer pop in your head? That's what source identification is. Just simply the swoosh. What are we thinking about? What comes to mind? That's what a good trademark is. But it could also be a color, like the color of a green garbage truck. It could be the color of a particular product, like pink insulation. These are all trademarks, and they're extremely valuable trademarks. So it is a unique symbol, and it identifies a particular product or service that has to be used in commerce. Now, there's an exception. It's called an intent to use, meaning I'm not using it yet, but I'm going to be using it soon. So we can file what's called an intent to use mark, but it's only for a limited time. Otherwise, we have to be using in commerce, and we have to prove it. And and that's not always the easiest thing to do in our trademark application. It cannot be confusingly similar to another trademark. And we're going to go into detail on what confusingly similar means. It cannot be descriptive for its intended use. And let me explain that briefly. Let's say I wanted to create an elevator company. And so I named it Elevator Company. Well, clearly that's descriptive of an elevator company. And so I cannot trademark Elevator Company for an elevator company. But if it was a farm or a computer company and I wanted to call it Elevator Company, well, that's not descriptive. And therefore it'd be a very strong trademark, and therefore trademarkable for the intended use. It has to adhere to a bunch of other rules and requirements that I can't, there's not enough time to get into. And even if there was enough time, I'd bore the heck out of you. But I'm going to give you some quick examples. But these examples come out of a 3-inch thick manual if we printed it. It can't be immoral or scandalous. That probably seems like you might understand that. It cannot be geographically significant. It's called geographically misdescriptive. It cannot be a surname. That's your last name. Cannot be a surname unless you have 2 or more surnames in it. Crazy rule. Cannot be a portrait or a signature of a living person or individual without their permission. Cannot be a deceased US president. Cannot be deceptive or falsely suggestive of a connection, meaning you like let's say Apple, I keep mentioning Apple. Let's say you like their computers and you want to be affiliated with them somehow. And so instead of saying Apple, you say, Fruit Computer Company. That still might give you a problem. You can't create this false sense of connotation. Trademarks are designed to protect the public. And if you think of that through that lens, then it might help you understand whether a mark that you want to trademark and protect is actually trademarkable. Coat of arms or signia of a government entity, also protected by statute. And one example of that is the word Olympics. That word is actually a statutory protected name. And you're gonna, if you have the word Olympics in your trademark, it's probably gonna get refused. So you need to be very careful about that. So let's pretend for a moment we have a mark for your business and you want to protect it. How is it protected? Well, there's 3 levels. The first one is common law. That basically means you're just using it. You haven't registered. You haven't done anything other than use it in the real world. You get some level of protection in New Mexico and most states. It's called common law protection. It's automatic. It's designed to protect the public. And it's only really geographically focused. So it could be limited to just the city or county you're in, but typically it's the state. So if you've been doing business for 20 years under a particular name and somebody comes on and starts using a very similar name, you can rely on common law to do something about that. The next level of protection is state registration, where you file a trademark application with the state of New Mexico or whatever state you're doing business in. The advantage there is it provides some additional levels of protection and damages associated with infringing use of your trademark. The problem with it is it's state specific and it can be overridden by what is going on at the federal level. And I'm going to say the words USPTO a lot, which stands for United States Patent and Trademark Office. So the USPTO is what monitors and maintains the federal registration database of trademarks. And anything at the USPTO is going to override everything at the state level. So my general advice is to always shoot for the federal level if you can, and then fall back to the state level if you can't do something at the federal level. But that's a little bit qualified. And what I mean by that is if the reason you cannot do something at the federal level is because of a likelihood of confusion, which we're going to talk more about in a minute, you don't want that trademark at all. Don't use it, because the trademark holder can sue you for trademark infringement. The legal test that the USPTO uses is the exact same test for trademark infringement. So if the USPTO says you're going to have a problem, they believe the legal test suggests trademark infringement. So if you go and use it anyway, even though you didn't get the trademark, you could still have problems with the trademark holder. They can come after you. And if they do come after you, it's a big problem. It's like going to a knife fight with a bazooka. They can have a lot of penalties, not just a restraining order and injunction, which means they can prohibit you from using the mark further, a court order to prohibit you from doing that, but they can ask for their attorney's fees and court costs. They could do what's called disgorging profits. What does that mean? Let's say it's the money you make associated with using that mark. You have to, show your financials and how much you made, and then pay them what you earned off of that mark. Plus, if any lost profits they can prove they lost because of your infringing action. And then in instances of willful infringement, and what that means is they have to prove you knew about their trademark and you went ahead and used it anyway, they can get statutory damages on top of everything else. That can go as high as $2 million per infringing use. It's a horrible idea to try and infringe somebody else's trademark. And when you go and file a trademark, the USPTO is going to come back and tell you, sorry, Charlie, you can't use it because there's a likelihood of confusion with this mark. You're on notice. So if you continue to go and use that mark, you could potentially have willful infringement thrown at you, and you don't want that to happen. So what can you trademark? Aside from this likelihood of confusion that we're going to go into detail a little bit, the question is, can you trademark the name? Does it meet the legal test of what the requirements are for a trademark? And based on the past few slides, you should probably know what some of those are already. One is, we want to make sure there is not a likelihood of confusion. Is the standard. It's not a direct hit. It's not an exact match. It's a likelihood of confusion. It's fuzzy. We'll talk about that. But it's, the general quick overview is it's another name or mark. So it could be sound, it could be a logo that is similar in look, meaning, or sound. Those are going to cause problems for you. I mentioned descriptiveness. It cannot be descriptive, or you're not going to be able to trademark it. There are hundreds of other rules I had mentioned. Geographic misdescriptiveness, geographic descriptiveness, surnames, just to name a few. So the question is, where on this spectrum does your mark fall? If we have this spectrum on the left where it's generic, descriptive, these are dictionary terms. They are not trademarkable. It's where they're suggestive or arbitrary that they are trademarkable as it relates to descriptiveness. So you really want to ask yourself that. And if you have a descriptive term, one way to find that out is to Google it. 50 million hits come up. If so, then you probably don't want to use that mark because you're just going to be lost in the shuffle with everybody else anyway. You want to come up with a made up word or something that's clever and suggestive. And that's not easy to do, by the way. So let's talk about this likelihood of confusion because it is confusing. It is a legal test and it's used for trademark infringement. And basically, if there's a pre-existing mark that is trademarked, so it's an existing valid trademark, will your use of your mark be likely to confuse a general member of the public with the existing trademark? And if so, we're going to have problems. So the question is, as it relates to the mark itself, is it similar? I'm not saying same, I'm saying similar in look, sound, meaning, or commercial impression. If so, we might have a problem. But that's not the only issue. We also care about the relatedness of the product or service. How similar are the other guy's products to my products? Same is not the issue. It's similar again. So for example, the USPTO has come back and said, coffee and donuts are similar. So if you are selling donuts and somebody has a similar name in coffee, you're going to have a problem. Perfume and sun tanning lotion, I've had some issues with. And for me, I feel like those are very different products. How on God's green earth could somebody get those two products mixed up? But I've been overridden on that one, and supposedly they're similar enough to create trademark problems. Coaching and consulting. I don't know. I've had issues with that. I feel like they're a little bit different, but what do I know? A website versus a retail store. They are viewed as similar for trademark purposes. Now, here's one that's going to surprise you. Expensive watches and luxury cars. You think, really? Those are very different things, cars versus watches. But when they're luxury, you're appealing to a very specific demographic and potentially a narrow range of consumers. And those consumers are looking for high-end brands. And so that is viewed as, possibly passing your trademark or name off with a pre-existing mark. And so they'll look at that. So it's really kind of surprising. You got to be really careful. But, when we're considering a trademark to register, we can't just look at the exact match, right? Synonyms are going to matter. So box versus cube, those are going to be the same things for trademark purposes. Abbreviations, so like lux versus luxury are going to be a problem. Translations, red versus rojo. Made up words versus regular words. And you see a lot of millennials, they'll change the ATE in a word to the number 8, and that could give you a problem. So it's not easy to do the right research to find out if you're going to have a problem with a trademark, let alone then filing a trademark application. We've had issues with common words in the same industry, even though they're different words. Athletics versus running has been a problem. Different forms of the same word, adaptive versus adapt. The first word is given prominence, a higher value. So if somebody had the word adaptive and I wanted to put adaptive somewhere else in my phrase or my string of words representing my trademark, I could have a problem, even if I put a bunch of other words in there with it. And so additional words may not be enough. In my example here, I use the word Google. That's a trademark, valid trademark, famous mark. And if I wanted to go and bury it somewhere, it's still not going to be okay. It's still going to be viewed as potentially creating a likelihood of confusion. And then the final thing I want to mention is, let's say I had a company called Larry's Fast Machine Learning. And it was for computer systems, AI. Well, fast machine learning would probably be considered descriptive for that type of business. Therefore, when we're considering trademarks, you just drop those words off. All we really have is Larry's. And so if there's somebody else out there with the word Larry's in anything to do with computers, I'm probably going to have an issue. And I probably don't want to do that. Now, conversely, if I had Larry's Fast Machine Learning for an apple farm, that's probably going to be just fine, assuming nobody else came up with a crazy name like that. So, let's do a quick test, coming up with a good name. Could you do McDougal's for a fast food restaurant? No, because it's sounds similar and looks similar to the word McDonald's. Can you do Federal Express for a shipping company? No, because there's FedEx. FedEx is not Federal Express, but they're similar in meaning. So we're going to have a problem there. Apple Farms for an apple farm? No, because it's descriptive. Homestead Office for a movie company? No, we got HBO. They look very different. They kind of sound very different too, but they're similar in meaning, I would argue. Digest for readers for a book company? No, you got Reader's Digest. Moving words around, spacing is going to be irrelevant for our analysis on whether we're going to have a good name or not. What about Albuquerque's Best Hamburgers for a hamburger restaurant in Albuquerque? You know where I'm going with this? No, it's descriptive, right? It's descriptive because it's geographically descriptive, Albuquerque and Albuquerque, and it's for hamburgers for a hamburger stand. What about Albuquerque's Best Hamburgers for a hamburger restaurant in Santa Fe? Is that okay? No, it's geographically misdescriptive because the word Albuquerque doesn't actually mean where it's located. So now we're being misdescriptive about it, and that won't fly either. How about Albuquerque's Best Hamburgers for a hot dog food company? No, deceptive, because we're describing hamburgers in our name and we're not selling hamburgers. So that's not going to fly either. So it could be a very, very frustrating process in trying to determine whether you can trademark a name. And therefore, if you have problems or you hit any of these problems here, I want to caution you on filing a trademark in the first place. You're probably going to be ending up throwing your money away. But let's talk about how we protect how you protect your trademark, assuming you've done some research and figured this all out. First is pick more than one mark. Be clever. Suggestive, not descriptive. Arbitrary is even better, although that tends to scare a lot of people. What is suggestive? Suggestive is something that kind of hints at what you got going on. Brown's Chicken, Greyhound Bus. What's arbitrary? Amazon for an e-commerce company, Apple for a computer company, Google for a search engine, right? Those are names that really don't have anything to do with what they do, but over time and through their market presence, they have established a meaning with those marks. Nike, what does the word Nike mean? I probably have to Google that and see what that means, but it doesn't mean a shoe company from a dictionary perspective, but it sure means one from a trademark perspective. 2, verify there's no likelihood of confusion with pre-existing marks. And I'm going to show you how to do this, but you want to search tests at the USPTO.gov. That's one option, and you got to remember all the rules I told you, or you could pay somebody to provide and interpret a trademark search. Costs a little bit of money, but it's much more effective and faster and will reduce uncertainty. And then my advice is to reduce a list you have to 1 or 2 marks. Now, a lot of people they fall in love with a name and they start using it. And I very much want to discourage people from doing that. You need to, just like picking a location for your business, you want to ideally not just, fall in love with one place, but maybe a few, and then pick the right terms, figure out where your customers are. You want to go through that analysis, and it's the same thing with your trademarks or marks. Finally, once you've determined or you believe you're not going to have a likelihood of confusion, I want you to file that trademark as quickly as possible. And let me explain why. In trademark law, what matters most is first use. Who was using the trademark first? That wins against anybody else in most, not all instances. The next important date is filing date. Who filed first? So a person who uses first can certainly win over somebody who files first. But when I say win, think fight. And do you know how to fight that? Probably not. So you're going to have to hire somebody like me, and I'm expensive. So when I say fight or probably win, think expensive lawsuit, spending a lot of money on legal fees. So it is a heck of a lot more expensive to be fighting about trademarks than to just get the filing date and then do it before somebody else does, so that you don't have to have that expensive legal fight. So that's why filing date is important, because if you file first and then somebody files next week, the United States Patent and Trademark Office, the USPTO, is going to suspend the other application pending your application. And if your application fails, then they will eventually unsuspend the other one and let that one proceed. But if your application succeeds, they will then cancel that other application. And that's a heck of a lot less expensive than having to hire a lawyer like myself and fight about all of this. So we're going to talk about filing online and how to do that in a minute. But I want to warn you, as I mentioned before, there's a high rejection rate, and it's because people don't know all these rules I explained just now. So you're not going to be one of those people. You're going to have this presentation, and before you go and spend your money filing, you're going to go and look through all those rules and see if your mark actually can be trademarked or not. And if it can't, you're going to go and come up with a new name, because brand names are really valuable and important. And you're going to go through that exercise and get a name that you can trademark and that won't be rejected by the USPTO. Now, I would recommend, if you're running into problems, talking to a trademark lawyer. And I got to warn you, I do a lot of, we call them CLEs in the legal world, continuing legal education. So I train a lot of other lawyers. And in particular, I do a lot of training around doing business on the internet and how the internet has created a very difficult situation for consumers, because we lawyers don't have the money, believe it or not, to compete with the big internet companies, because they're venture funded, venture capital funded. Me, I'm funded by when people pay their legal bill. So they will have ads and internet websites that will be seen before a lot of the lawyers' websites are seen. And they are giving really basic, limited advice. And I use trademarks as an example of why the public is being harmed with how things are set up today. And what I mean by this is you're going to find, you type it now or later today, type in register a trademark. The first page of results, there isn't going to be a single lawyer on there, and everybody's competing for the lowest price because people price shop. Makes sense, but they aren't helping you understand what these issues are. So you'll see trademark people saying as low as like $39, and all they're doing is asking you the information that the USPTO asks to put on the application. They're not actually looking at your information and saying that's a bad idea or you want to do things differently. And that's a big problem for me, because 80% of the people that come in contact with me, they want to register a mark like Apple Repair Center. I kid you not. Somebody wanted to file Apple Repair Center. And my response to them was, I think that's a great name if you want to get sued by Apple Corporation and pay me a lot of money. I think it's a bad name if you find that's a problem. So I end up telling people not to do business with me because the marks that they want to trademark are bad or they're going to fail. And I just know that with my 30 years of experience. So I can't afford to do trademarks for people for $39. I just can't do it. So that's a really good example where you don't want to price shop for trademarks. Find somebody that you can trust and actually is a trademark lawyer. That's really the only way to make sure you do this correctly, in my opinion. So let's go through the process now. We titled this seminar, How to File Business Trademarks. And so now let me explain and show you how to do that. And you're probably thinking, why did I go through 30 minutes of what a trademark is? And the reason you did that is because I don't want you to waste your $250 or more filing a trademark That's not going to work. And worse, I hope you heard me when I said this. If the USPTO rejects your trademark application for likelihood of confusion, guess what? You have notice of a potential infringing issue. And if that trademark holder comes and sues you later because you refuse to stop using your trademark, you can run into some very problematic and costly damages associated with that. So simply filing a trademark isn't without consequences. So you need to be aware of what you're doing and the implications, and you need to be able to walk away from your trademark if you find out you are potentially infringing on somebody else's trademark. And if you do think or find out that you could be infringing on somebody else's trademark, don't risk it unless you got plenty of money and you want to throw a bunch of money at us. And then we're happy to take your business and do that. But very few businesses are in that position. So the first thing you want to do with trying to, file a trademark is to figure out your class codes. And this link is where you go to do that. And remember, I told you, you can ask the New Mexico SBDC for a copy of this presentation, so you don't have to write this down. You could just cut and paste if you have the presentation. But this is a master list of class codes. And this is probably the first time you've heard of class codes, and I'm going to explain what this means with an example. So this is that link. If we were to go to the USPTO's Trademark ID manual, this is what you're going to be presented with. And specifically, it's like a search, like you're used to with Google or other search engines. We're going to search for specific descriptions of our product or service. So in my example I'm about to show you, I'm going to type in hard candy. I'm going to think of a name here. I'm going to show it to you in a minute for hard candies. And when I type that in, the USPTO comes back with a list of items and what they mean from a description and class code perspective. It's almost like an NCAIS database, where you have how you classify a product or service into marketing segments. It's the same thing here. So hard candy or hard candies came back as class code 30. So it's possible I could have just typed in candy and we would have seen a ton of hits. You can imagine there's people who sell candy as well as people who manufacture candy. In this particular case, we're seeing class 30, which is relating to manufacturing. It's a good versus a service. This is the class code I care about for hard candy. And therefore, it is the class code that I would use when I'm looking at the trademark database. Now, class codes are really critical and important because they help identify my product or service. Clothing would be class 25, by the way, but that's not enough for the USPTO. They want to know, what kind of clothing? Are they shirts? Are they pants? Are they dresses, coats, socks, undergarments? So I need to be a little bit more specific in the clothing category, but they'd all be class 25, and we'd see a really long list if I typed in clothing, for example. But suppose you do consulting for clothing and you do marketing as well. Well, you can imagine those being 3 different class codes, one for the manufacturing 25, marketing or helping people with marketing, helping others with marketing would be probably a class 41 or 42 or 44 that relates to a service of providing consulting services or marketing services. SaaS-based businesses where you're producing an application, those could be multiple class codes depending on what you're doing and how you're doing it and who you're doing it to. But why you care about the class codes is, one, it greatly affects expense. The trademark prices applications based on the trademark and its class codes, and it's $250. So if you had one trademark with 2 class codes, it would be $250 times 2. It would be the same thing as just 2 trademarks with 1 class code each. So it greatly adds to the cost, but it does a few other things. It expands the breadth of my trademark so that I have a broader trademark with more protection, and it prevents others from honing in on what it is I'm doing. Finally, when I file a trademark, it's possible the USPTO is going to have a problem. And if they have a problem, it's going to be on a per class code basis. So they could say, hey, we're going to reject your application because of one of the two class codes you specify. Well, in trademark law, I could do what's called a divisional, split up the trademark application into two so that I can fight with the USPTO on the one refusal, but allow the other class code to proceed and at least get my trademark going, even though I'm still dealing with one of the class codes. So it's a strategically sound thing to do to add as many class codes as you can, but it's costly. So you really need to think about those issues. But why am I harping on about class codes? Well, because now we're going to do what I call a trademark assessment. Before we file our trademark application, we want to make sure there aren't going to be other problems. This is the likelihood of confusion issue that I raised. So this is the link at the United States Patent and Trademark Office where I can search for other trademarks. And so we're going to go to that. And it looks like this. And what we care about is the one in the middle called the structured search. So we're going to search for trademarks and we want to do a structured search. And the reason being, this is the page it looks like when I go into it. I want to type in here a few things. Specifically, I came up with the name Sour Duke for my hard candy. So I put that in the search term, and the field is going to be full mark. I'm searching for Sour Duke in the full mark fields of the US Patent and Trademark Office database. Now that operator on the far right, it defaults to or. I want to change it to and. On the next line, search term, I'm going to put 030 for my class code 30. And the field is going to be international class. So I want to search for my trademark, Sour Duke. Now, remember what I told you about likelihood of confusion. It's complicated, and the US Patent and Trademark Office doesn't do a fuzzy search. They'll do a couple of things around pluralization and spacing, but that's really about it. So you really need to do a bunch of different searches using this interface. Start with your exact phrase, but then change sour to other synonyms of sour. Change sour to translations, Italian, French, Spanish. See what comes up. Also, separate the words. Just search for one word or search for the other word so that you get a full view of what could potentially be an issue in class 30. So with my example here, here's what comes back. It found 6 records with sour or Duke, and you can see how I mentioned that pluralization. Well, in this particular case, it's not pluralization, but, well, one of them is, but possessive. So it'll do a reasonably good job of dealing with S's and trailing S's and removing them, but that's about it. I am not going to dive into each one of these because we could spend all day analyzing them. What I will tell you is when I looked at them, the Dukes that are live, those are the ones we really care about, related to nothing around hard candies. I want to say it was barbecue sauce. So I feel like if I was basing my search for Sour Duke for hard candies on this alone, we're probably okay. However, this is not a good search, right? I should go back and I should, like I told you, come up with synonyms, come up with different translations and so on for the word sour, for the word Duke, and see what else comes up and look at those. I'm not going to do that for the sake of time right now, but this is a very important exercise that should take you a few hours to really vet and make sure that there aren't any potential problems. So let's pretend that we haven't found any problems, and now we're moving on to filing a trademark application. So what do we do there? This is the link. So I've showed you 3 different links. This is the final one, and this is where we can file our trademark application. And it looks like this: apply online. And it's a long page, and I'm just scrolling down a little bit because we care about number 1 here, initial application forms. The other forms on this page deal with issues further on in the process. As you can see with number 2 below there, response forms. If the USPTO had questions or they refused it, we'd probably care about some of the forms in number 2. But here, for filing a business trademark, we care about number 1. We're going to click that, and we come to another page. It's the initial application form. Now, what we're going to do is click that little box here in the center to start our application. It's called T's. And there are 2 types of applications. It's the same button, though. One is called T's Plus, and the other one is T's Standard. I recommend everybody focus on T's Plus because it's less expensive and it's more structured, meaning it forces you to answer questions in a certain way that will improve the likelihood of success. If you go with a T's Standard, you got to know what you're doing a little bit, and you're creating an opportunity to make more mistakes and therefore increase the chance of your application being refused for some reason because you made a mistake you weren't aware of. So let's click on that button, and what do we find? We find this. It's a sign-in page. It's a little bit annoying because you have to set up an account, and then they require a double verification. They'll email you or text you a code. You got to go through all of that. But once you do, you're going to be presented with a form like this. Now you're in the TEAS system, which is short for Trademark Electronic Application System. It's pretty fast, but it's very text heavy. And even as a lawyer, I get a little intimidated by this because they change it regularly. And so when I think I know exactly what's on this form, I'll then notice, hey, wait a minute, it's a little denser, or it's just a little different. And then I'm like, uh-oh, so then I got to read the darn thing and see what they've changed. So it gets a little annoying, but I'm going to scroll down to the bottom of this. And what's nice is I could save my work and come back to it. And you could do the same thing. However, they will, when they update their system, I told you they do that regularly. When they update it, your saved work no longer works anymore. It doesn't apply. So make sure you print out what you've entered so that they'll give you the ability further on to print out a PDF of your input, of the information you've given them, and you can refer to that PDF if they go and make an update between when you saved your work and when you went back to it. So it's just a really good way to save your work. But we're going to click on this continue button, and this is the first page, and I'm not going to go further because I struggled with this. The form can change, or the information you put in can change drastically depending on what you put in. And so I felt like we'd spend 2 hours with me trying to come up with all the different, the flow chart, if you will, depending on what you put in. But what I want to show you here is that you're going to have to define the owner, and the owner I recommend being a company. A lot of people want to own the trademark themselves, but use it for a company. And there are some tax issues down the road, ownership issues down the road, if you're not very careful with that. So number one, if you're not operating as an entity, you have a business, you don't have an LLC or corporation, get one. And I would recommend an LLC because it's not very expensive, it's very easy to set up, and it provides a lot of benefits. If you have that LLC or corporation, it should be the owner of the trademark, and you'd click the relevant button here on what kind of entity it was. but it doesn't have to be a company. It can be you if you want it to be. I'm just recommending you don't do that, or you're very careful and you understand what the issues are if you make it yourself. What I want you to be aware of is don't screw up. And why? Because we are submitting an application that is tied to affidavits stating that what is on here is true and correct. So let's say, for instance, my name is Larry Donahue, and I wanted to get a trademark right away, and I followed my own advice, and I'm gonna get an LLC set up, but I don't actually have the LLC set up yet. So I go and put in the name of the LLC, knowing I'm gonna form that LLC in a few days. So I put the name of that LLC in here. Seems okay, right? And then I fill out the application to move on. But then, for whatever reason, the state rejects my LLC application. It's too close to another name out there for some reason, so I got to change it. Well, now I have a big problem because I told the US Patent and Trademark Office, this was the owner, this is the name, but it turns out that company didn't actually exist. So now I have a problem with my filing, and I may have a critical error associated with that. And it's a lot of work, and it could be a lot of expense to try and fix that. So don't screw that up. So I'm going to leave it here on this particular page, but there's some more important information that's critical for you to know before you move forward. And I want to explain that quickly. So first one is, I talked about class codes, and I want to restate that. They're important, but they increase costs. It's better to have more if you can afford it. And likewise, if you are in a business that is doing 2 or more different things and you only want to get a class code for one, you cannot enforce your mark against users in those other class codes. So you need to think about what's important to you as it relates to your mark and preventing the competition from using something that's confusingly similar. There are 2 types of trademarks, and I talked about this a little bit earlier, and I want to reinforce it. There's what's called a Section 1A. That's a trademark you're currently using. Your first use date is sometime in the past, earlier than what your filing date is going to be. Section 1B is for the intent to use trademarks. These are trademarks that we're not using yet. Our filing date is going to be the earlier date of the actual use date. So you can file a trademark without actually using it. But here's the issue with Section 1A. These are trademarks you're currently using. You have to submit specimens. And I can't tell you all the folks that have their trademark applications rejected because they didn't submit sufficient specimens. Now, I have a link here. It's a little arcane with a lot of legal mumbo jumbo, but it does a good job of breaking down the different types of specimens. For instance, if you're selling on the internet, it will tell you how the specimen needs to look. If you are, doing business at trade shows or, local farmers markets, it has a section for that. And you may not know this, but if you have a picture of your logo, that's not a specimen. You need to back up and take a picture of the logo on a product in a public square or place. If there are people around, that's even better. But guess what? That's not necessarily enough. The USPTO wants to see that it's tied to a point of sale somewhere or somehow. So it's clear that the product is there to be purchased. Now, that's different from an advertisement. Advertisements are a solicitation to purchase. So if you had an advertisement in the phone book, I don't want to just see the advertisement. I want you to back it up so you can show clearly that the advertisement is in an actual book or a newspaper or wherever the advertisement is. If you don't do these things for the specimens, the USPTO is going to reject your application, and now you're going to have to deal with all of that. So it pays to understand that a little bit and then produce the right specimens, which are basically photographs of your product or service in commerce with the mark. That's what a specimen is. So 1B is the opposite. It's the intent to use. You don't need to cough up specimens. And by the way, I just saw that Jessica asked a question about class codes. Can you go back later and add more class codes? And the answer is yes, you can. It's still a new application and it's going to still have the same fees, but you can certainly do that as your business builds and expands. You can go in and add more class codes, assuming somebody else hasn't moved in on those other products or services that you're thinking about expanding into. But yes, you can do that. Now, with section 1B, my bullet point 4 here, it's important for you to understand that you don't need specimens, which is great because you could just submit the application. But you don't actually have a registered trademark, even if it's approved by the US Patent and Trademark Office. What you have is called a notice of allowance. You are given the ability or right to get that registered when you submit what's called a statement of use. When the USPTO approves the trademark application, you have 6 months to produce a statement of use. A statement of use says, I've started using my trademark on this date, and here are my specimens. So you got to have those specimens. If you can't get your act together within that 6 months, that's okay. You get another, you can file what's called an extension, and you get another 6 months. And you can keep filing extensions up to 3 years. After the 3 years, you're out of luck. So you need to be able to cough up a statement of use within the 3 years in filing those extensions. Now, the one problem with the 1Bs here, the intent to use, is that every time we talk to the USPTO, it's a fee. They're always charging us for everything. So if we're filing an extension, we're paying for that. And it's by class code. So if you have one trademark with 3 class codes, they're hitting us 3 times to file that statement of use or the extension. So the intent to use trademark applications cost more because we have to go back to the USPTO and at the very least, file that statement of use within the first 6 months. And if we can't do that, file an extension, then file a statement of use after that. So there's going to be more cost to that. And you got to be careful with the dates. You cannot miss the dates. If you miss the dates by even a day, you lose your trademark application. Now, there's a process. Maybe you have to what's called petition to revive. And guess what? That costs more money too. And that's not a for sure thing. So don't miss the darn dates is what I'm trying to say. Otherwise, an intent to use can be a very powerful way to get a trademark registered if you know you're going to be using it. And that, oh, I had one more thing about this. A lot of people ask me, it's going to take the USPTO 5 to 7 months to even look at the darn thing. So I just want to warn you about that. There's a long time horizon on this, on whether the USPTO is going to approve or reject. And if they approve, you got another 2 to 3 months to wait until it's finalized and you're holding a registration certificate and are issued a registration number. And why is that important for some people? If you are selling on Amazon, for instance, and you're trying to protect your name on Amazon, or you got people out there that are infringing your mark, Amazon's not going to do diddly until they have a registration number. And so you're looking at legitimately, 7 to 9, 10 months before you get all of this finalized and approved by the USPTO at the best. If they reject things, they have questions, they will issue an office action. You'll have 6 months to respond. It could take years to get your trademark in the worst of circumstances. So it's something that you want to not delay on and move forward on. But that is it. I appreciate everybody's time and interest and patience. If you have any more questions, now is a great time to ask it, unless SBDC wants to see anything more.
Yeah, thank you so much, Larry. That was really valuable. I had no idea it would take that long to get the whole process dealt with. So, wow, That is quite something for sure. I don't see anything in the Q&A. Don't be shy to ask if you have any questions. And in the meantime, we just want to remind you that the NMSBDC is here to help you during any stage of your business. So don't hesitate to reach out to us. And yeah, just want to thank you for joining us. Please visit our website at nmsbdc.org to view our upcoming no-cost webinars or to sign up for our no-cost counseling services. And then Larry, I'm not sure if you're seeing it in the chat, but we've got a thank you, very excellent presentation, and another thank you coming at us. So yeah, thank you so much. We appreciate it greatly. And if we don't have any, oh, do we have something else in the queue? Oh, another thank you. So I think unless there are any more questions, we'll go ahead and wrap this one up. Unless you want to say something, Larry?
No, I am good. I appreciate everybody's patience and listening with me, and good luck to you.
Excellent. Thank you all so much.